Morning.
Morning, morning. Any mentioning?
Yes,
Lordship.
my lord, am I audible, my lord?
Yes.
My lord, may I have your lordship's kind leave, my lord, to mention this matter which was mentioned on 4th of this month, my lord. Your lordship was pleased enough to direct me, my lord, to put the state on notice, my lord. The applicant lordship recollects what the mother who is not getting her salary from 20.
Yes, yeah, we remember.
Yes, my lord. I have now, my lord, put the state on notice, my lord. If I lord,
Tomorrow we will list it.
my lord, I'm so grateful, my lord. I'm so grateful.
Tomorrow.
Your Lordship, I crave leave to file an appeal without the certified copy, Your Lordship.
Date of the order?
25th of June 2025, Your Lordship.
Yes, leave granted.
My
Lord, may I permit to
that-
mention
that-
application for inclusion in the list, man? Yeah.
Yes, yes. Please hand over the slip.
Please, my lord, I am mentioning that contempt application NBSCC till now they have not complied.
That is along with Justice Hiranmay Bhattacharya.
Yes,
No, who was sitting along with me in that bench?
that is Justice Pattonayak.
Oh, Lordship is here.
That NBSCC matter they have partly complied, but it was due date on 1st July, but has not been complied. So, my lord, I am handing over the slip.
All right. Probably next week, subject to convenience of His Lordship, we will sit one day, about say at around 3 o'clock or so, or 3:30. So next week we will give you a date. You please inform the
Yes,
advocate for the Transport Corporation.
Lordship, I'm paying for leave in this matter, Lordship. I have several occasions mentioned this matter, Lordship. The file is was not found, Lordship. That therefore I have mentioned this matter.
In fact, our court master has verified from the department what is the outcome of
They have
that.
sent a report and they said the file is not found, Lordship.
All right. Then you do one thing. You make a full photostat copy of 2 sets.
Lordship.
And you bring it tomorrow.
Lordship.
We will direct that to be treated as a original till the original is traced out, and then we will list the matter.
Grateful, Lordship. Grateful.
You make clean photograph.
Lordship, may I permit to mention one motion matter for inclusion in your Lordship's list?
Group 4, Group 6. Which group?
Group 9, Your Lordship.
Group 9 won't come here. You please ask the court master. He will tell you which court. Yes, Mr. Kanode.
Lordships, I beg to mention serial 45 of the monthly list appellate side, Lordship. That was that Henneman issue, Lordship, wherein your Lordship had not granted interim stay. And in the meantime, we had to depart. It was kept for final hearing, the jurisdiction of Bureau of Investigation. Your Lordships told that we will take it after 12th of this month. So, Lordship, because now what has happened, they have initiated recovery proceeding. And this is for 17-18, 18-19, 19-20, 20-21. Same issue. It is pending, Lordship. But for 17-18, because they initiated recovery proceeding, we have deposited 2 crore rupees and filed a statutory appeal. That appeal they dismissed on the ground of limitation. Against that, we are pending before we filed a writ before the single bench now, which is pending, Lordships. So if your Lordship decides the issue of jurisdiction of Bureau, Lordships, then entire 5 years will get over, Lordships.
Mr. Siddiqui is appearing for the response.
Lordship, Mr. Siddiqui and Mr. Tonaya sir is appearing, Lordships. Subject to your Lordship's convenience, any day whenever Lordships are available.
You ask their convenience also.
Lordships.
Inform a consent date.
Lordships.
We will include it.
Grateful. It is in the monthly list, Lordship. I will mention again after picking there.
You inform the court officer, that's enough.
Grateful.
They will upgrade it to the daily list.
Much obliged, Lordship. Grateful, Lordship.
Lordship, may be permitted to mention item number 94 of the monthly list of the original side, my lord. This issue already in your Lordship already considered in other cases also. My issue is whether the cess paid under the Sugar Cess Act can whether they are eligible to take the send-back credit or not. Lordship, it is a tribunal on the basis of our judgment decided the issue on that case. That is Sri Renuka Sugar. My lord, kindly take up the matter in any day.
No, I think we have decided a similar issue.
Yes, my lord. Already it has been decided.
It is a covered matter.
Yes, my lord.
And who will appear for the respondent?
I have forgotten, my lord. I am candidly saying.
No, you will have to.
I will check. I will inform, my lord. I will inform them.
Letter along with the copy of the judgment saying that we mentioned to the court.
I will do. In the meantime, my lord, before listing, I will do. By today itself, I will do that.
You do it and you give that letter. Based on that letter, we will advance the matter.
Then I will say hand over the letter to the.
hand over the letter after serving copy along with the the judgment you are relying upon. You serve respondent and then hand over that acknowledgement letter to the court officer. He will include it.
Grateful, my lord. Grateful.
My lord, on 2nd July, this matter was taken up, my lord. My name has not been recorded. Order.
Okay. You please give. We'll show it in the days. Appellate side or original side?
Original side, my lord.
The bench is another. Your name.
My lord, may I mention, my lord?
Yes, Mr. Shah.
My lord, I'm just, my lord, requesting again, my lord. Sorry, my lord, it is an embarrassment regarding that, my lord. Megaplex matter, my lord. Kindly take it up, my lord. Please.
No, in fact, I have discussed with Justice Hiranbhai Bhattacharya. Probably next week, second half, we will sit.
Yes,
there are other matters also along with this lordship. We'll club that and we'll finish it off.
Yes, my lord. My matter, my lord, I assure that I will not argue any further. Mr. U.S. Bhattacharya will just conclude his argument, my lord, distinguishing the judgment cited by me. That's all.
We remember. We'll do that.
Lordship, my other side, I just spoke 15th Tuesday, my other side is available for that matter.
Okay. Then we'll list it on 15th. Immediately after fresh cases.
Grateful, dear Lordship. Much obliged.
May I have your lordship's leave to mention a few matters for admission of appeal under section 30 of the Employees Compensation Act, my lord?
Please give the numbers.
Grateful, my lord. There are 5 appeals, my lord. Grateful.
Original side daily list.
Item number 4.
But I'm appealing for the respondent.
They've given a letter for withdrawal.
So they want to withdraw because they have availed the Vivad se Viska.
Please take down item number 4.
4 and 5.
This is 5. Yes. What is the name of the SSC? Okay. Item 4, IT 8098 of 2024. This appeal has been filed by the SSC under section 260 Cap A of the Income Tax Act 1961, within bracket the Act, challenging the order dated July 24, 2023, passed by the Income Tax Appellate Tribunal A Bench Kolkata, within bracket Tribunal, in IT.
My lord, the SSC have already gone for the VSB scheme.
In ITA number 47/KOL/2023 for the assessment year 2020-21. The learned advocate appearing for the appellant SSC has circulated a letter seeking leave to withdraw this appeal on the ground that the appellant has availed the benefit of the direct tax Vivad se Vishwas scheme. To the said effect, the appellant has addressed a letter to the learned advocate for the appellant dated 22nd July 2025. In the light of the said submission and taking note of the letter given by the appellant to their advocate dated 2nd July 2025, this appeal is dismissed as withdrawn. The substantial questions of law which have been suggested by the appellant SSC are left open. Let the letter circulated by the appellant to their advocate, learned advocate, be kept on record. The same will be the order for item 5. The only difference will be ITA number 46/KOL/2023 for the assessment year 2018-19. Otherwise, everything is same. Item 4 and 5 over.
Grateful.
Grateful, your lord. New application tax matters, item number 6.
I'm for the respondent, lordship.
Yes, madam.
Mr. Somen Bhattacharya is appearing in this case, my lord. He is suffering from fever, my lord. He has not come to court.
Things are raining, morning, all roads fully blocked. 478 days, my goodness. What is the issue?
Lordship, the issue involved here is penalty which has been imposed under section 271E of the Income Tax Act in respect of loans which were converted into bonds, lordship. That's the issue.
And what did the tribunal hold?
Lordship, the tribunal has held that since there was nothing in the quantum assessment, so the CIT could not have enhanced the penalty in the guise of section 68, Lordship. You cannot take a penalty route for making action in relation to section 68, Lordship. Since there was nothing in the order of original assessment order, as well as the penalty was imposed only for the conversion of loans into bonds, Lordship. That is the reason that the tribunal has given the relief, Lordship.
All right. What do you say about the delay? Are you objecting to the delay?
Lordship, I am objecting to the delay. Lordship, kindly refer to para 4 of the.
Then you file your affidavit in opposition. Let us see.
Okay, Lordship.
There is a delay of 478 days in filing the appeal. The learned advocate appearing for the respondent assessee seeks time to file affidavit in opposition. Let such affidavit be filed within 2 weeks from date. Reply, if any, within a week thereafter. List the matter. You give a date after 3 weeks.
Lordship, grateful.
For admission of tax matters, item number 7.
I am for the appellant, my lord.
Delay has been condoned?
Yes, my lord. Delay has been condoned. This is a reopening case, my lord.
And who appeared? Pratyush Jhunjhunwala appeared.
Yes, my lord. Yes.
Lordship, in this matter, I am led by Mr. Pratyush Jhunjhunwala.
Yes, he's coming. He's come. Yes, Mr. Amit Sharma, please tell.
My lord, the tribunal has held that the information was already available with the assessing officer, and assessing officer has reopened the case without recording reason that the assessee has failed to disclose particulars fully and truly.
No, Mr. Sharma.
My lord.
Paragraph 2 of the tribunal's order.
My lord, kindly come. This particular assessment order starts pertaining to this assessment order starts from page 56, my lord, para 4.
No, it says the learned counsel for the assessee further stated that most of the issues raised in the appeals for
my lord, these assessments are not for this appeal. The assessment years mentioned in paragraph 2 are not the subject matter of this appeal.
Okay, 910 is para 4.
493. This is my lord, page 56. Kindly come to page 56.
Okay, yes.
Para 4. My lord, the finding of the tribunal starts, the relevant paragraphs are paragraph 11. Start from paragraph 11, my lord.
Paragraph 10 onwards, my lord. He's even recorded the reasons have been reproduced.
Officious transaction report. STR.
At page 60, my lord, the fourth line, as per section, I'm reading from the first top, my lord, which could indicate that assessee has furnished any inaccurate particulars in written or has not disclosed fully and truly or material facts necessary for the assessment. As per section 147 of that, until and unless the learned assessing officer records a finding that there is a failure on the part of the assessee to disclose fully and truly all material fact necessary for the assessment, the reopening of the assessment after 4 years from the end of relevant assessment year cannot be taken.
You open it.
Therefore, from my paragraph 12.
But what the tribunal says is, some accounts of the assessee were not rejected. They were all placed. See, the name of the assessee is
Jilanders Arbuthnot.
So what was the suspicion?
The transaction with SR, my lord. SR Sales Corporation.
And funds transferred by the assessee to company SR Sales have been immediately withdrawn.
Yes.
So the transaction of the assessee with SR Sales is duly recorded in the books, and the books of accounts were placed before the assessing authority in the course of regular assessment. Books of accounts have not been rejected, and detailed inquiry has been conducted while carrying out the assessment. Quantitative records are maintained. Transaction has also been part of those scrutiny proceedings. All details related to transaction are already placed. There is no new information brought on record.
Yes, my lord. My lord, kindly come to the page 58, my lord. The reasons for which the assessment was reopened.
But even if I may kindly take page 57 once, paragraph 8, to show the documents that were placed even before the tribunal, and my lord, even from the order of the Commissioner of Income Tax Appeals, wherein my submissions have been produced, I can show that even VAT returns, the bills, the VAT invoices, everything was submitted, but nothing has been considered. And
That
only
was
on the basis of this.
Ex parte order, is it?
But it's not an ex parte order, it's just that he doesn't consider anything. Neither the AO nor the CIT appeals, they've not considered. But very briefly, if I may indicate, my lord, what has happened is that I have purchased cotton. I am into, my lord, I'm maintaining a mill wherein I'm using cotton yarn. Now, my lord, the transaction is that I have purchased cotton yarn from SR, from this entity, my lord. What has thereafter happened, my lord, is that in the course of regular assessment, my books of accounts, everything was produced before the department. They looked into my cotton mill unit also. They disallowed certain other expenditures. Nothing was done with respect to my purchases, your lordship. Now, what the department has done is that they have received some information from the investigation wing that these transactions have to be looked into. My lord, before this information came to the assessing officer, a 131 notice was issued to me on behalf of SR Sales. I responded to that. I provided all the details to the department in Punjab and Haryana, your lordship. After that, he still issues an information to the assessing officer here. The assessing officer has only relied upon this information and has initiated assessment proceedings. In the course of the assessment, as well as before CIT appeals, your lordship, I gave copies of invoices, I gave copies of excise reports, I gave copies of lorry receipts, I gave a copy of a VAT form, which, my lord, is in fact required for the purposes of interstate movement of goods, which is duly inspected after the goods leave from one state and enter into another state before it leaves. That was also filed before all the authorities. Nothing has been considered, your lordship, nor by the assessing officer. He doesn't even say that where is the information that I've provided. That is incorrect. And even he simply relied on the basis of whatever information has come from the investigation wing. He doesn't conduct his own inquiry. And the only basis of the addition is that when the assessing officer in the course of the reassessment issues a 133.6, the other party does not respond. But nothing, not a whisper, either by AO or by CIT appeals to the documents I've filed. And also, your lordship, the information, he's not conducted any inquiry, your lordship. It's a settled proposition.
The of the purchases were not doubted.
Nothing, my lord. None of the purchases were doubted. My sales, even this is a point taken by the tribunal, and even I had placed that my corresponding sales have not been disallowed. My books, my lord, my stock, there has been no adjustment made to my stock. Everything has been accepted. So, my lord, on what basis is my purchases being doubted? My sales, my stock is not being doubted. My books are not being rejected. Everything is being accepted. I filed a plethora of documents. If my lord may kindly consider para 8 of the tribunal and even before
the reasons that it is extracted, what is the tangible material they rely on?
My lord, it's only the report, the STR report that has come.
That is not sufficient, sir. Sir, once in the scrutiny assessment, the books were all produced. He has produced the VAT form. He has produced the invoices. Movement of goods have been proved. Purchases not doubted. Sales not doubted. Merely because some money was transferred by RTGS and withdrawn immediately by SR Sales, that is the reason. 131 notice, due compliance has been there. 133.6, why he will comply? He is in another state, why he will submit to your jurisdiction?
But even the figures are not correct. I even mentioned before the authorities that the figure of 99 lakhs is also not correct. My actual transaction 94 lakhs. Even to that, they don't respond.
Where is your, is there any, your reply to the 148?
But if my lord may kindly take the submissions before the CIT appeals, right, because that is very in a lot of detail. My lord, CIT appeals order starts at page 20. My lord, on merits I've answered from pages 43 onwards, my lord. Page 44, my lord, brief facts and submissions. Those are my grounds. And then on brief facts and submissions, but I'm listing out all the documents I filed before Commissioner of Income Tax Appeals, which were also filed before the assessing officer. But I say that the assessee during the year under consideration made purchases from SR Sales Corporation. The purchases are duly supported by movement of goods from the place to the party to that of the assessee's place of business. To support the genuineness of the purchases as made by the assessee, the following documents were duly filed during the course of the assessment proceedings. The documents though were not doubted at all by the department, but the same were totally ignored and the addition was purely made on the basis of the information. So I have the documents, copy of the ledger, copy of the purchase bills, I've given the page numbers, copy of excise declaration issued by the party SR Sales Corporation, LR is my lorry receipt, copy of road permit, copy of packing list, and thereafter my principal, I would say, the closing document is VAT. My lord, it is pertinent to mention here that as per VAT law, the government through its excise and taxation departments has set up its checkpost barriers at all entry and exit points from where the physical movement of goods entering into or leaving outward the state of Punjab takes place. At these checkpost barriers, the officials of the aforesaid department at the rank of the assistant excise and taxation department were on 24 duty. Each and every truck and any other goods carrying vehicle are stopped by the officials.
There is nothing. Please come. This appeal filed by the revenue under section 260 capital A of the Income Tax Act 1961 within bracket we had is directed against the order dated May 3, 2024, passed by the Income Tax Appellate Tribunal C Bench Calcutta within bracket tribunal in ITA number 493/KOL/2023 for the assessment year 2009-10. The revenue has raised the following substantial questions of law for consideration. Page 6 and 7 of the state petition 1, 2, and 3. We have heard so and so. The short issue which falls for consideration was whether the reopening of the assessment was validly done and whether the learned tribunal was justified in allowing the assessee's appeal and setting aside the reopening of the assessment. The assessee during the year under consideration had made purchases of cotton from Messrs. SR Sales Corporation. They are located in Punjab. Sales
Haryana.
Located in Haryana. The assessee filed the return of income showing total income of nil. The return was processed under 143 within bracket 1. Subsequently, the case was selected for scrutiny and notices under section 143 within bracket 2 and 143 within bracket 1 were issued. In response to the notices, the assessee was represented by their authorized representative and appeared from time to time before the assessing officer along with books of accounts and other details as called for. The assessing officer opined that the assessing officer completed the assessment under section 143 within bracket 3 by order dated 28/12/2011, accepting the submissions of the assessee. Subsequently, notice was issued for reopening the assessment. As could be seen from the reasons for issuance of notice under section 148, the assessing officer relied upon a report termed as suspicious transaction report in the case of SR Sales Corporation. And based on that, the assessing officer opined that he has reason to believe that income of the assessee chargeable to tax has escaped assessment within the meaning of section 147 of the Act. The assessee submitted a detailed reply to the notice proposing to reopen the assessment. However, the reply did not find favor with the assessing officer, and the assessment was and the objections were rejected, and the assessment was reopened and completed by order dated 29/12/2016.
My lord, may I want?
Yes, sir.
One thing, my lord, because I did not get the opportunity. My learned friend interrupted me and started making submission.
Yes, sir. Please tell.
Yes. My lord, here the assessing officer had issued notice to the SR Sales to verify the genuineness of the transaction.
Correct.
And it was those notices returned with the remark left.
Understand.
That is at page 18, my lord.
Yes, I have seen that. We have seen that.
Second last paragraph, my lord.
I've mentioned the fact now that 133.6 went unresponded.
131 notice, they responded. 133.6 returned.
131 was given by the investigation wing, my lord.
But
Deputy
130
Director.
but
That is separately. Here, 133.6 was given to the SR Sales by the assessing officer.
The 131 was a response filed by me when the authorities in Haryana were conducting the investigation. After they had access to SR Sales Corporation's books and accounts.
131 was issued by the Deputy Director of Income Tax Investigation, Rotak.
Yes.
To me.
Yes, to the assessee.
Yes,
then nothing happened thereafter.
And I replied, my lord. I filed my reply with all the details.
You filed the reply. Thereafter, they did not do anything.
No. But then, my lord, the report to the assessing officer.
Then the suspicious transaction report was drawn. Yes, please tell.
Here, my lord, the sales the purchase have been doubted by the assessing officer.
No. Show one place. Show
my
from.
On the basis reasons, my lord.
No. Reasons does not say anything more than it says it revealed that the company SR Sale was getting funds from the assessee, and immediately after that cash was being withdrawn by SR Sales. It was observed by ITO Investigation Wing Headquarters, Gurgaon, from the ledger account of the assessee that 99,35,000 has been shown as payment against purchases of cotton yarn from SR Sales Corporation during the financial year 8-9. In the above perspective, I have reason to believe. What reason to believe? Nothing is there. Sir, please read where I stopped.
The assessee submitted a detailed reply to the notice proposing to reopen the assessment. However, the reply did not find favor of the assessing officer and objections were rejected. An assessment was reopened and completed by order dated 29/12/2016.
Agreed by order dated and added rupees 99,35,000 to the assessed income of the assessee company. The assessee preferred appeal before the Commission of Income Tax Appeals, National Faceless Assessment Center in NFAC, Delhi, which was dismissed by order dated 29/12/16. Agreed by the same, the assessee preferred appeal before the learned tribunal, which has been allowed by the impugned order. The first aspect to be considered is whether the reopening of the assessment for the reasons which have been recorded was justified in law. It is evidently clear from the records that The books of accounts produced by the assessee were not rejected by the assessing officer. Rather, they were not considered by the assessing officer nor by the first appellate authority. The assessee to substantiate their purchases had submitted
At page 44.
Yes.
Page 44, my lord.
Submitted several documents in the course of the assessment proceedings. It is evidently clear that the documents were not doubted by the department, but have been ignored. The documents which were produced by the assessee are the copy of the ledger account of Mrs. SR Sales in the books of the assessee, depicting the complete details of purchases as made by the assessee, and also establishing the fact that payments have been made through banking channels. Full stop. The assessee produced copies of the purchase bills from SR Sales Corporation, a copy of excise declaration issued by SR Sales Corporation, copy of the lorry receipt, copy of the road permit, copy of the packing list. Apart from that,
and also the bat.
Yes, I'm coming to it. Please. Apart from the above, the assessee also produced the relevant documents which are issued under the provisions of the Value Added Tax Act. It cannot be disputed by the revenue that the documents which have been issued by the VAT authorities are issued after a thorough check of the goods while in transit by way of an interstate movement. In this regard, the assessee has enclosed about 50 documents in the form of a paper book before the assessing officer. That apart, the assessee produced the audited books of accounts along with all supporting bills and vouchers, and the same were accepted by the assessing officer during the assessment proceedings. The balance sheet and the audit report of the assessee mentioned about the stock tally of the raw material and finished goods. Therefore, the assessee, by placing reliance on the audit report and balance sheet, submitted that the raw material purchased from SR Sales Corporation has been utilized for production of finished goods and have been sold, and the balance, if any, is maintained as closing stock. This aspect was not doubted by the assessing officer. That apart, the assessee produced complete details regarding opening stock of cotton purchased during the year under consideration, the quantity used for manufacturing process, and the closing stock. And the department did not make any adverse remark with regard to those details. Thus, the learned tribunal took note of these factual details and held that the reopening of the assessment is bad in law. In more than one place, the learned tribunal has pointed out when the books of accounts have not been rejected, the transaction cannot be doubted. And the assessment could not have been reopened. In the light of the said factual background, we are of the view that the learned tribunal was fully justified in allowing the assessee's appeal and setting aside the reopening of the assessment. Thus, we find no question of law, much less substantial question of law, arising for consideration in this appeal. Accordingly, appeal fails and is dismissed.
I'm grateful, Your Lordship.
Next.
Item number 8.
My appeal, my lord.
Yes, sir. What is this?
My lord, this is issue is 263, my lord.
Okay.
The assessee had acquired two properties. The primary issue is that the assessee had acquired two properties. One is leasehold property, another is freehold property. And the sales consideration was lesser than the consideration valued by the registering authority. That aspect was not examined by the assessing officer. Therefore, the PCIT had invoked provisions of 263, my lord. Though the 63 was invoked for several issues, my lord, on those after considering reply of the assessee, 3 issues were accepted by the PCIT. Only on 2 issues, the PCIT had directed the assessing officer to examine. My lord, here the tribunal in appeal has held that on the basis of this judgment, relying upon the judgment of Synotia Metals and Minerals, that held that this 263 was invoked at the instance of the assessing officer. This is the but here the fact is that, my lord, this 263 was invoked on the basis of audit objection. Audit objections were raised. Thereafter, the assessing officer apprised the PCIT, and PCIT, after examining the records, had invoked 263, my lord. This is one aspect. One on ground, the tribunal allowed the appeal. On another ground is that this section 56 to 10 is not applicable for leasehold land. The tribunal has held that.
Let us see the assessment order. First, where is the assessment order?
Assessment order is at page 16, my lord.
You show the relevant paragraph with regard to the valuation of the property where he has discussed it.
But there is no discussion in the assessment order on this.
So that is the reason. All right. Now let's see the show cause notice. Which
Page 41, my lord.
41.
Paragraph third paragraph, my lord, at the bottom.
So only that valuation aspect is the only point in this appeal.
There's yes, my lord. Basically, on this is the primary point. There is another
Okay.
issue, my lord.
Let's see the reply to the show cause, page 45.
Page 45.
But on this, my lord, will find the reply, my lord, at page 79, lord, on the valuation part. Lord.
But before the assessing officer, when he completed the assessment at 143.3, they had produced a copy of the valuation report. And the assessing officer was satisfied with the report. Did he refer the matter to the valuation officer?
No, my
No,
lordship.
He should have, no? See, one point they say is that this provision was inserted subsequently with effect from 1/4/2017.
Yes, madam.
The purchase agreement was entered on 31st December 2016. Part performance, part consideration paid in January 2017. Therefore, they were of the view that, genuinely of the view that 56 to 10 will not apply.
May I submit, my lord, on this? My lord, the 31st/12/16 document was agreement for sale.
Yes.
That was not the document by way of right was transferred.
No, no.
Deed of assignment was executed on 27th of March 2018.
The transfer definition under the Income Tax Act is very wide. You have appeared in several matters we have held. And there is part performance, part consideration paid.
My lord, the subsequent document which was registered by way of the transaction was concluded was on 27th of March 2018, my lord.
But merely can you go by the district, I mean, stamp valuation report.
My lord.
And what are these judgments? Calcutta High Court, Sinhotia Metals, Kharabi Drillers.
Sinotia matters, my lord, that invocation of 263, in which it was held that the if the matter reference at the reference is made at the instance of the assessing officer, the invocation is bad. On this point, my lord, I have a judgment of my lord judgment, my lord. Is Beena Gupta's case. यही है ना सिनोटिया में सिनोटिया
We'll take it up tomorrow.
My lord.
Better, because the papers are bulky.
Yes, my lord.
Take it up
And my
tomorrow.
lord, I will cite some judgments also.
Yes,
And
you
I
please.
will also place, my lord, the Maharashtra incentive scheme, my lord. That has been also discussed in the tribunal's order, my lord.
Okay.
And I'm handing over a copy to my learned senior friend.
Yes, please. Next, tomorrow, please tomorrow. You have heard so and so.
Item number 9.
Mr. Mitro, you are appearing.
I'm appearing this matter. My lord, may I come back tomorrow with this matter because Mrs. Swapna Das is appearing in this matter for the SSC. She has requested me, my lord. She couldn't come to the court and she is unable in the virtual mode as well, my lord.
All right, no problem.
I'm getting.
Not today.
Switch over to appellate side.
Appellate side. Yes.
Or I'm for the respondent, my lord. This matter, this is an old appeal. In this matter, this is a very old appeal. The respondent has retired upon superannuation, and while this appeal was pending in 2011, now, my lord, I have filed an application wherein, my lord, I am praying for release of some point retirement benefit, which has been specifically mentioned in paragraph number 34.
And why is it coming under the caption to be mentioned?
My lord, I mentioned this matter on behalf of the respondent. This is appearing under the heading to be mentioned. But if your lordship so kindly considers, if your lordship kindly passes an order that if the appellant wants to prefer any affidavit in opposition against my application, let them file it in the meantime, or your lordship may kindly fix any day so that my application can be heard out.
Mr. Ranjay Dey, senior advocate, is appearing.
Yes, I am for the appellant, lordship. The matter is ready, paper books are ready. Lordship, the matter can be heard out. Any date subject to lordship kind of.
It is against an order of punishment, is it?
No, this is not an order of punishment, lordship.
No.
Normal retirement, the issue relates to promotion. There is certain provision in the promotion that he was posted at Chinsura, the district of Hooghly, and so far as our promotion policy is concerned, that comes within the purview of Calcutta urban agglomeration, and he was also enjoying CCA, city compensatory allowance, on that basis. And so far as promotion is concerned, there is an insurance company, lordship. The collection is based on that cities, and my defense client applied for the promotion where his collection was less, but he did not, and as such he did not get the promotion. He challenged the same, and then learned single judge was kind enough to allow his writ application. We have come in appeal.
So the issue is that he wanted him to be promoted from the post of Inspector Grade 1 to the cadre of Assistant Administrative Officer.
Yes.
As per the promotion policy, and the learned single bench is allowed.
Yes.
Now, he retired. In which post did he retire?
So that
Mr. Day, did he retire as Inspector Grade 1? Or
well, subject to correction, he retired as Assistant Administrative Officer, subject to correction.
All right. Now, where is your claim form?
If your lordship kindly comes to pay paragraph number 32, I had made an interim application before this honorable court, wherein pursuant to the direction passed by this honorable court, a portion of my retirement benefit was allowed and it was paid to me. Now, rest amount is not paid to me, which has been, my lord, stated in details in paragraph 34. By this application, I am praying for release of the said amount, which has been stated in paragraph 34 of my application.
Now, see, page 34, page 25, you
Page
say
25, my lord.
Provident Fund 1,36,000. Now, this Provident Fund, is it based upon in the promotion post or based on the court order or otherwise?
This is as per my own calculation. So, if the opposite party, if the appellant wants to dispute anything,
see, the thing is, if they are disputing your eligibility to be promoted as Assistant Administrative Officer.
My lord.
Suppose, according to them, you did not achieve the target or something, as per the promotion policy, you are not entitled to. Let us assume for the time being that Mr. Debashish Mukherjee he is appearing from his bedroom, he is arranging the bed pillows, etc. Sir, you mute the camera, sir. Mr. Debashish Mukherjee. All right. So what I'm trying to put across is, there will be a disputed amount, there will be an undisputed amount. If you can mention what is the undisputed amount, accepting the case of the insurance company, assuming they succeed in the appeal, what will you get? Assume they failed in the appeal, what will you are entitled to? That undisputed amount we will release now. What do you say, Mr. Ranjay?
Already we have paid as per the honorable court's kind direction regarding this.
Where is that order?
Increment is already paid, lordship. If your lordship kindly consider the order dated 30th November 2016. We have already paid 3,48,477. So far as the increment is concerned.
Your lordship will find the order at page 77 and 78.
Prior to that, lordship, we have also paid 10,15,513 on the account of gratuity and leave encashment.
Oh, all right.
Already paid.
So therefore, as per the interim direction, release his retirement benefit as per their own calculation without treating him as promoted in the terms of the judgment. Okay. So we have to hear out the appeal. All right.
Yes, lordship, kindly.
But in that case, lordship kindly considers that some more amount under different heads are still required to be paid
undisputed, undisputed amount has already been released. So, subject to the outcome of this appeal, this interim order has been passed. So, we can't allow your application, CAN 3, but we can advance the hearing of the appeal. That can be done. Because if you see page 77,
my lord,
it's the interim direction. So, over and
yes, it's an interim direction.
Over and above that, if suppose something has to be released, it will tantamount to allowing dismissing the appeal.
Even if I go by the direction passed by this honorable court, which is at page 77 and 78, some more amount is required to be released in my favor, which I have stated at paragraph number 34. So, my lord, I was beseeching your lordship, if your lordship directs the appellant to file an affidavit in opposition stating in details as to what they are disputing and what they are not disputing, that will make the picture much clear.
Yes, sir. You can ask your client to do that. Insurance company.
May I submit only subject to lordship kind approval. What has just fallen from your lordship, if the appeal is being heard and if it is being some decision is there, he will be entitled to everything whatever he wants.
But his wife is suffering, sir. He has spent 12 lakh rupees on her treatment. So if according to you, please respond to paragraph 34. If anything can be released which is not disputed by you, we will attempt. You get written instruction. You need not file affidavit in opposition. We will grant you a week's time and say that let the appellant respond to the prayer made by the respondent petitioner in para 34 of Can 33 of 2025. We have heard so and so. The appellant insurance company is directed to give written instructions to the learned advocate on record for the appellant with regard to the plea raised by the respondent petitioner in paragraph 34 of Can 3 of 2025. List the matter next week.
Can it be little more time, lordship, for 2 weeks, lordship, subject to lordship kind approval?
2 weeks already. So today we are on 8th. 22nd.
Deep level.
Lordship, I have some personal difficulty in 22nd, 23rd, and 24th. In that case, may be listed after that, my lord.
Then it will come on 29th under the same caption.
I'm so grateful to Lordship. I'm so grateful to Lordship.
Next.
Item number 2. 29.
Lord, 2, I am for the respondent petitioner, my lord.
But today they have given a letter saying that because of rain, lot of advocates are unable to reach the court.
Lordship, so far as the earlier matter is concerned, may I pray for only 1 day most extra, lordship, 30th. I will inform Mr. Dey. I will inform Mr. Dey. 30th. Dada, ওটা 30th হবে.
All right, sir. Item 2 we will say not today. Let it be in the list.
2-4 for admission item number 3.
My lord, item number 3, I beg to appear virtually, my lord.
Very good.
My lord, with greatest respect, my lord, learned single judge admitted the writ petition, my lord, and gave direction for exchange of affidavit and also granted conditional stay order upon payment of 10%, my lord. My lord, this is case of 17-18, my lord, initial year of GST. I am businessman, my lord, of healthcare and diagnostic service provider, and my entire outward, my lord, supply is completely exempt supply, my lord. What happened, my lord, in initial year of GST, from August 17 return, I wrongly availed the input tax credit, and thereafter, my lord, in the next year, January 19 return, 18-19 year, I reverse the entire ITC, my lord, much before issuance of the proceedings. And my lord, in the appellate order, they admitted that I reversed the ITC, but in 4B2 column in place of 4B1 column. And also the electronic credit ledger, my lord, it is evident that I never utilized the ITC, my lord. And my lord, rightly and admittedly, they did not levy interest. Rightly not levied, my lord, because there is retrospective amendment in section 50 of subsection 3 of the GST Act from 1st July 2017.
But what is Mr. Himanshu Ray?
My lord.
Along with the discretion exercised by the learned judge, 10%.
My lord, here, my lord, they admitted, my lord, that I reversed the ITC, my lord. Kindly have a look, my lord, at the appellate order, my lord. Page number, my lord, starting page 142 and operative part, my lord, page 150, my lord. 150, my lord. Lordship got, my lord? Yes. Middle page, my lord, para 5.9. May I read, my lord? I find the appellant has submitted consolidated GSTR 3B, that is during hearing. It is seen that the ITC has been reversed under others category. In table 4, it has not been reversed under rule 42 row. Thus, it is apparent that reversal was some other account. I am drawing, my lord, your lordship, kind attention, my lord. My lord, page number, my lord. 162, my lord. The 3B return, January 19, my lord, 3B return. Middle portion, my lord, 4B, that ITC reverse in the chart, my lord. I reverse in the chart, my lord, that others column, my lord. They are saying that you have not reversed in column 4B1 column. So I reversed in others column. And my lord, this entire fact, my lord, I have given in a chart tabular form in page 159. They enter this chart, my lord, reproduced in the appellate order, page 159, my lord. These are the chart. They are admitting, because this chart they have reproduced in the appellate order. I will show you, lordship. They are saying that you have already reversed, but in others column. And my lord, admittedly and rightly, they did not levy interest because they knows that I have never utilized the ITC. They indirectly they admitted. So, my lord, in this case, there is no tax is payable. And ITC I never utilized, my lord. It is evident from the electronic credit ledger, my lord, that I have annexed in the page 157 and 159, 8, my lord.
And in your where is the original authorities order adjudication?
Yes, my lord. Order in original, my lord, is starting page 111, my lord. Because this is the ex parte adjudication order, my lord. Order in original is ex parte, but appellate order is in parte.
You have reversed it under the head others.
Others, my lord. But I reversed.
No. Whether from the others column, can that be taken to the whatever rule 42? 42.
Rule 42 and rule 43 is not at all applicable because this is the mismatch rule, my lord. That also omitted, my lord. And that never came into force, my lord. And in the appellate order, my lord, they reproduced my chart. They admitted that I have reversed. So ultimately, no tax is payable, my lord.
But the original authority at page 113 says that...
Yes, my lord. Because, my lord, this is ex parte original, my lord.
Who appears for the respondent department?
My lord, I am appearing, my lord. Let Banerjee, my lord. My lord, here the issue is, my lord, excess availment of ITC, my lord. He is providing exempted service as well as taxable service, my lord. If your lordship kindly see the appellate order, it has been categorically stated by the appellate authority that he failed to provide the GSTR 3B for the August 2017, my lord, because he is claimed that I have returned it, I have reversed it in the month of August. Now that, if your lordship kindly see para 5.8, page number 150, my lord, the appellate authority stated that, my lord, he has not filed any GSTR 9 annual return to reconcile that what amount he has reversed, what he has availed. Sir, in absence all these documents, how it can be crystallized before the authority that he has availed the ITC or he has reversed the ITC properly, my lord? That considering this, my lord, the appellate authority has directed to reverse that excess availment of ITC. Now the learned single judge, my lord, directed to extend the affidavit and to secure 10%. Your lordship earlier occasion, my lord.
No, that is correct. We have dismissed it, no problem. But the fact remains that he has reversed.
That is reverse is not proper, my lord. If your lordship kindly see para 5.7.
Then you refund it. Then you refund that money. We will ask him to reverse it in terms of rule 42.
My lord, the question is that he is accessible, my lord. Question is accessible, my lord. He's providing, if he's providing only exempted service, my lord, is otherwise he's providing taxable as well as exempted service.
Sir, he accepted his mistake and he reversed the credit wrongly availed. But
your lordship, my lord, if your lordship kindly see, my lord, I am just reading para 5.6, page number 150, my lord, of the appellate authority order, my lord.
You please read.
My lord, the appellant on the other hand had provided statement duly recorded in para 3.3 supra justifying the reversal on the common credit. I find that the appellant has not denied the demand of reversal alleged by the lower adjudicating authority, thereby acknowledging that they were required to reverse the common credit which was availed and utilized by them for effecting exempted service supplies. However, I find that
this is harassment, sir. This is harassment. You read para 5.7. What he says, he cannot ascertain whether reversal of the appellant was from excess common credit availed by them, etc. You ask for a reconciliation. You call that man. Call the
before the adjudicating authority, my lord, he failed to provide all the documents, my lord.
Sir,
and before the appellate authority, my lord, he has not also provided that GSTR 9C annual return, GSTR, my lord, 70, GSTR 3B for the month of August 2017, my lord. If your lordship kindly see, however, it worth mentioning that the appellant has failed to submit GSTR 3B for the month of August 2017 in order to corroborate the fact of mentioned by them. Further, it is also worth mentioning that without a proper reconciliation statement for the financial year 2017-18, it would be very difficult to ascertain whether the reversal made by the appellant on 9/1/2018 was for the excess common credit availed by them. Thereafter, my lord, it is
all
further.
right. No, you stop there. Come back to page 147.
147, my lord.
Para 3.3.
Para 3.3, my lord. But in form GSTR 3B for the financial 2017 and 18, ITC claim from our end is amounting to rupees 48 lakhs such and such, and rupees 11 lakhs such and such in the CGST SD separately. So this amount is already being reversed. The reversal is made in the following manner. Thereafter, my lord, firstly, in the form GSTR 3B for the month of August, my lord, he has not provided this document, my lord. It's recorded in the order.
Sir, his case is the assessing officer, adjudicating authority did not issue show cause notice. If he had issued show cause notice, he would have come before him and said, sir, these are my documents. This is my reconciliation statement. And this chap has produced it. He has extracted it. That is why the final paragraph 5.9 of the appellate authority's order is absolutely vague. What does he say? This is an ex parte order of the adjudicating authority, and the adjudicating authority says he didn't respond. According to him, show cause notice was not issued.
My lord, we have issued the show cause notice. It has been sent to the common portal. We have given opportunity of hearing, my lord. It is not at all an ex parte order, my lord.
Now, my lord, ex parte order, show cause issued, but we missed at common portal not issued by mail. We missed the show cause notice, and my lord, that is why ex parte order. And my lord,
opportunity of hearing has been given, my lord. If you lordship kindly see,
All right,
page
no.
113.
Have you submitted GSTR 3B?
Yes, my lord, submitted, and the chart, my lord, that reproduced in page 148 middle portion, my lord. That chart, my lord, annexed page 159, similar chart reproduced and accepted by the appellate authority, my lord. That, may I read, my lord, the chart? Middle portion, my lord, 148. This is my given chart, my lord. That chart attached in page 159. That ITC available 17.8p as per annual 3B such and such, outward liability such and such, ITC reverse in the month of August such and such, net ITC reverse on August 2017 such and such, ITC reverse 17-18 such and such, ITC reverse 18-19 such and such, net ITC reverse 17-18 and 18-19 on 18 February 2019 such and such, net ITC reverse 17-18 and 18-19 such and such. So he accepted that I reversed the ITC.
Mr. Ray, you come to page 150, paragraph 5.9, 5.7.
My lord.
Fourth line from top.
My lord.
However, it is worth mentioning that the appellant has failed to submit GST 3B for the month of August 17 in order to corroborate facts. But in your tabular column, you are saying GSTR 3B for financial year 17-18.
He has submitted all the returns submitted, my lord. This is contradictory,
Mr. Banja.
My lord.
whether he has extracted the tabular column.
My lord, it is that his own calculation, it is on tabular form. Now what the authority has come to the conclusion that in absence of GSTR 3B, in absence of annual return, it is not possible to corroborate the statements, my lord.
He says that he has given GSTR 3B.
My lord, then this is the wrong recording on the part of the adjudicating authority, appellate authority, my lord. They are saying that considering the records documents that he failed to produce
No,
the
let it go back. Let it go back. Let it go back to the adjudicating authority. Please take down. This intra-court appeal by the writ petitioner is directed against an interim order.
But learned single bench order, my lord, page 23, my lord.
Interim order passed by the learned single bench by which, while granting an interim order of interim stay, the appellant was directed to deposit 10% of the tax in dispute. Since the issue raised in the writ petition lies in a narrow campus, with the consent of the learned advocates on either side, the appeal as well as the writ petition are taken up for consideration and are disposed of by this common judgment and order. The issue is whether the appellant has reversed the ITC, which has been wrongly availed by them. It appears that though show cause notice was served by email to the assessee, appellant, they did not respond to the show cause notice. This resulted in an ex parte order being passed by the adjudicating authority dated 14/12/2023, passed by the Assistant Commissioner, Central Goods and Service Tax and Central Excise, Dinajpur Division, Raiganj, Uttar Dinajpur. Agreed by the same, the assessee preferred appeal before the Additional Commissioner, CGST and Central Excise within bracket appeals, which was dismissed. Since the tribunal has not been constituted, the appellant has filed the writ petition in which an interim order was granted, subject to certain conditions. Before the appellate authority, the appellant, in no uncertain terms, has stated that they had filed GSTR 3B and produced a tabulated statement of how the reversal of the wrongly availed ITC has been done. The appellate authority has extracted the submissions made by the appellant verbatim in the appellate in the order.
Page 148.
In the order dated 4/10/2024, the tabulated format shows the details of the ITC available for the financial year 2017 as per annual GSTR 3B return. However, the appellate authority in paragraph 5.7 of the order dated 4/10/2024 would state that the appellant failed to submit GSTR 3B for the month of August 2017 in order to corroborate the facts mentioned by them. Thus, there appears to be a factual dispute which needs to be sorted out, and that can be done if the assessee is given one more opportunity to reconcile the defect which has been pointed out. If the assessee has already reversed the ITC, then the matter becomes revenue neutral and the question of making a pre-deposit also would not arise. What are the notifications which you have filed?
My lord, notification, my lord, no notification, my lord. That's amendment in section 50, subsection 3, my lord, that if the ITC availed and reversed, that Finance Act 2022 amended with retrospective effect from 1st July. If ITC availed but not utilized, then there will be no interest. And rightly, my lord, they did not levy any interest in the adjudication as well as appellate order.
That apart, we note that the adjudicating authority did not levy interest on the appellant, which you go to show that the ITC has been reversed. In any event, these are all matters, factual matters, which needs to be adjudicated before the authority. Accordingly, the writ petition, writ petition as well as the intra-court appeal are allowed. The order passed by the appellate authority dated so and so 4/10/2024 is set aside, and the matter stands remanded to the original authority, namely the Assistant Commissioner CG and ST and CE, Dinajpur Division. The appellant is directed to treat the order in original dated 14/12/2023 as a show cause notice and submit their detailed reply along with all documents to the adjudicating authority, who within a period of 15 days from the date of receipt of the server copy of this judgment and order. On receipt of the same, the adjudicating authority shall afford an opportunity of personal hearing to the authorized representative of the appellant, consider the documents and the submissions that may be made, and pass fresh orders on merits and in accordance with law.
And my lord, subject to correction, the treatment of pre-deposit in appeal, my lord.
Pardon?
I have already deposited pre-deposit in appeal. That treatment of the pre-deposit, my lord, may be one line, my lord.
No, the pre-deposit which has been made by the appellant while filing the appeal before the Joint Commissioner shall abide by the orders that may be passed by the adjudicating authority.
My lord, I'm so grateful.
Well, also the timeline fixed by your lordship in filing the reply to the show cause is mandatory. In default thereof.
Yes. In default, you finish him off.
My lord.
Yes. Next.
Item number 4.
My lord. Item number 4, my lord. With greatest respect, my lord, learned single judge, my lord, admitted the writ petition and gave direct for exchange of affidavit and also no stay granted, my lord. What happened, my lord? For the assessment year 18-19, this is, my lord, third round of litigation. My lord, in the first round of litigation, I challenged the 143.3 order for the assessment year 18-19. The writ petition dismissed. Thereafter, my lord, I filed revision under section 264 before the revisional authority. The revision was dismissed. Thereafter, my lord, in the second round, I filed writ petition. The writ petition was dismissed. Thereafter, my lord, filed memo of appeal and stay, and your lordship sitting at courtroom number 16, my lord, remanded the matter to the 264 revisional authority on the grounds of violation of principle of natural justice. Thereafter, my lord, 264 authorities held detailed and remanded the matter on 15 July 2022 to the original assessing authority and directed to pass fresh assessment order. My lord, till date, my lord, no notice of hearing nor any assessment order is passed. And my lord, according to section 53, subsection 6, subclause Roman 1, that assessment order is barred by limitation after 31st July 2023. This is the first point. And any proceedings after that, my lord, without jurisdiction. Thereafter, my lord, on 2nd August 2024, suddenly, my lord, without passing that assessment order, the jurisdictional assessing authority issued 148 capital A small b notice. And my lord, I submitted reply within time and prayed for personal hearing and stated all the fact. In my reply, after my reply, my lord, they passed the order without affording personal hearing. And my lord, that their allegation are two allegations. Number one, my lord, that 30 lakhs for one party, I categorically stated that I have no transaction. And my lord, secondly, the 37 lakhs, I stated that I have property transaction with them. So, my lord, according to, without prejudice my submission, according to this situation, these proceedings is also barred by limitation by virtue of section 149 subsection 1 clause A. Because, my lord, below 50 lakh, my lord. And, my lord, otherwise, my lord, this as order, 148 order, my lord, 148 capital A, D order and notice is also, my lord, beyond scope of show cause notice. Because in this show cause notice, my lord, the allegation of unsecured loan was not there. But in the order, there is allegation of unsecured loan, my lord. May I show, my lord, the 264 order you lordship?
No, they have issued a notice of demand.
No, they issued 148 notice after 148 capital AD order. This is completely without jurisdiction and also barred by limitation.
So the writ petition has been admitted.
writ petition
Has been admitted, my lord, has been
no stay
admitted.
given. And my lord, the department in now will proceed, my lord. The yesterday, my lord, only yesterday, I am carrying, my lord, the copy of the 142 notice. They issued 142 one.
Pratidorya,
Yes,
if
my lord.
you proceed with the assessment, then the writ petition will become infructuous.
My lord,
See,
yes. My lord, yesterday the notice was issued. That information I don't have, my lord.
No. See, once the writ petition is admitted,
Yes.
prima facie show that they have made out a case for
Yes.
admitting the writ petition. And if in the meantime, if you proceed with the reassessment, the writ petition will become infructuous.
My lord, yes.
It will result in multiplicity only. Then what he'll do, he'll file a supplementary affidavit, bring on record the reassessment order, then
My lord.
an objection
My
saying
lord,
that
I understand. My lord, yes.
this is an intra-court appeal by the writ petitioner against the refusal of to grant an interim order by the learned single bench while admitting the writ petition in WPA 24427 of 2024. In the said writ petition, the appellant had challenged an order passed under section 148 capital A within bracket D of the Income Tax Act 1961 within bracket the Act dated 30th August 2024 for the assessment year 2018-19 on various grounds. The learned single bench was of the view that the matter cannot be decided without calling for affidavits, and therefore directed the affidavits to be filed within 2 weeks from the date of the order, that is 13/6/2025. However, it appears that the respondent department is yet to file their affidavit in opposition within the time permitted by the learned writ court. If interim orders are not granted, then the writ petition itself is liable to become infructuous, since reassessment proceedings will be commenced and concluded. That apart, as against an order passed under section 148 capital A within bracket D of the Act, the Income Tax Act 1961 does not provide for any statutory remedy such as appeal or revision, and therefore the petitioner, therefore the appellant are required to approach this court under Article 226 of the Constitution of India. Furthermore, there are a lot of decisions to state that reopening of an assessment to be resorted with utmost care and caution, and reopening cannot be done based on change of opinion or without any tangible material. In the instant case, the appellant has alleged violation of principles of natural justice, which has to be gone into after affidavit in opposition is filed. Therefore, we are of the view that all further proceedings pursuant to the order passed under section 148 capital A within bracket small d dated
30th August 2024.
30th August 2024 and the consequential notice issued under section 148 dated
30 August 2024, page 205.
shall remain stayed till the writ petition is heard and disposed of. The time for filing affidavit in opposition by the department is extended by a period of 3 weeks from date, and reply, if any, within a period of 2 weeks. It was open to the parties to mention before the learned single bench for inclusion of the matter for hearing.
Grateful, madam.
Grateful.
Next.
Lordship, I appear in serial number 5 for the appellant. Lordship, in this case, I know I am not on merits, but I am on a very point, Lordship, that since 2024, the first time this matter was called by the learned single judge on 1/7/24, and department sought time to seek instructions. Then on 15/7/24 again, it was listed for instructions. Then, Lordship, it came on 5/5/25 before the learned single judge. The learned single judge asked the department officer to be personally present in court. On 16/6/25, the departmental officer was present in the court, and in the meantime, some interest was paid by them. But Lordship, on the last occasion when the matter was made returnable on 23rd June, the respondents took the plea that this writ is not maintainable before the Honorable Single Judge. After 1.5 years, Lordship, a plea was taken that this writ is not maintainable, and therefore I was told my writ was disposed of with the direction to go to WBTT. Lordships, in fact, Lordship, this case has a checkered history, because prior to this writ, Also, there was a writ WPA 950024, wherein the learned single judge had passed order, basis which we had got the VAT refund from the department. Now, the question was, since 2013 till 2024, I was not given my refund of 1.56 crores. Then in 24, I got my refund of VAT. They did not pay me interest. I came before the writ court, I made representations, and then I came before the writ court so that they can consider my representations or the grant of interest. 1.5 years they sat tight on my representations. On the returnable date, when the proper officer was called by the Honorable Court to the court, then only 3 days before that, they passed an order sanctioning me only part interest. My interest claim was 1.15 crores. They sanctioned 69 lakhs.
I'm not unmarried. Bolo na koi.
And Lordship, on the last day when this final, in fact, Lordship may see the page 37 of my stay, wherein the learned single judge had recorded that there is a dispute of interest. Page 37, page 20, page 27, Lordship. 27.
Now, out of the total claim for interest, more than 50% has been repaid.
1.15 was the total claim as per me, Lordships. 1.15 crores. Out of which they have given me 69 lakhs odd.
During the pendency of the writ petition.
Just before, on the 4th of 10th of June. And that got credited on 15th of June. Just one day.
What about what is the stand for the balance amount?
Lordship, balance amount, Lordship, may kindly see my objection. Lordship, I have filed an objection at page 101.
Have they passed an order?
No, Lordship, they have passed me they have saying, Lordships, that 1.5, my total amount which was refundable, VAT was 1.56 crores. Now, out of that, Lordship, there was certain recovery, my demand which was I had to pay for earlier years. So, netted off that amount and paid me the refund.
Mr. Kanodia, order has been passed at page 97 by the authority, Deputy Commissioner.
Lordships, calculating the interest.
What is your remedy available against this order?
27. Lordship, that remedy under the VAT Act, Lordship, I had come for that is not an appealable order, Lordships.
That is what you want to know.
That is not an appealable order, Lordships.
So therefore, your writ is maintainable.
The plea before the single judge was, Lordship, taken by my learned senior, was that we have to go to WBTT.
Why?
Because it is under VAT Act, and VAT jurisdiction is with the taxation tribunal, not with the learned single judge.
No. If as against this order passed by the Deputy Commissioner, there is no appeal provided under the Act.
There is no appeal.
Then you will have to file an application before the tribunal. It will be numbered as RN or something.
Lordships.
But writ was maintainable, in fact.
Lordship, my only plea was, since 1.5 years I am chasing for interest. Now when the matter finally comes, they give me some, and this plea is taken by my learned senior that, okay, you are not maintainable, you again go back. 5 years back, I will again go, Lordships. If they let them consider, and during the pendency of the writ, they have issued this order.
All right. Now, where is your objection to this order at page 97?
Page 101, Lordships.
What is the order passed by them?
Lordship, the order passed, Lordship, at page 99, if your Lordship sees.
No. For 101, what is the order which they have passed?
That is what, Lordship, page 99, which your Lordship was seeing. My refund, the refund sanction order.
Correct, sir. In the page 99, 68 lakhs has been ordered.
Lordships.
Your claim is 1.15 crores. Did you raise an objection before the authority that your computation was wrong? I want 1.15 crore.
That is at page 101, Lordships.
You said, have they passed any order on your objection?
No, Lordships, no.
That's what I want to know.
I didn't got my Lordship. I apologize for that. It was actually, Lordship,
right.
it happened during pendency of it.
We can do one thing. Subject to what Mr. Siddiqui says, we'll keep the appeal pending. Let him pass an order on 101.
Lord, we can pass an order on 101. Your Lordship may kindly keep the point of maintainability open, because your Lordship was raising that query whether the rate was maintainable or not. Under the West Bengal Taxation Tribunal Act, my lord, the rate is not maintainable.
Why?
Specified act.
It is a specified act under the West Bengal Taxation Tribunal.
My lord,
maybe, but But if there are exceptional circumstances like Radhakrishnan Agarwal, that judgment.
Lord, of course, there are exceptions, but there is no exceptions circumstances, my lord, as far as this case is concerned.
1.5 years, this fellow was waiting, this dealer, and you sat tight on his refund
No,
application.
my lord, that was done, and the personal appearance which my learned friend calls says, my lord, he has been repeatedly submitting about that personal
Or
appearance.
we can do one thing,
Because
Mr.
of the
Kananda.
latches of the learned advocate, we were not ready with.
We can dispose of the appeal by directing him to pass a speaking order on 101.
My lord, we can do that. Is it felt from your lordship, my lord? We can do that.
Otherwise, to list this,
Because on merit, my lord, I could have filed an affidavit saying that, my lord, that he is not entitled to that interest, but still, my lord, he can pass a reason in speaking order. Whatever falls for me, lordship, my lord.
Lordships,
I bought on to your lordship.
This intra-court appeal by the writ petitioner is directed against order dated 23/6/2025 and WPF 14955 of 2024. The appellant prayed for a direction upon the authority to sanction interest on the refund sanctioned for the excess value-added tax
Form 27 is
paid for the period 2014-15, while the order dated 2/5/2024 and 17/5/2024 from the date of appeal order dated 18/1/2018 passed by the Joint Commissioner Commercial Taxes Dharmotola Circuit till and such interest to be payable till the date of actual refund credit. The writ petition was filed in 2024 and the matter was pending, and from time to time certain observations and time to time the matter was adjourned, and the learned writ court had made certain observations while adjourning the matter. During the pendency of the writ petition, the original authority, namely the Deputy Commissioner of Revenue, Chandani Chowk and Princess Street Charge, passed an order on 11/6/2025 granting a refund, rupees 68,82,735 to the appellant for the delayed payment of refund during the delayed payment of refund. The claim for refund made by the appellant is more than rupees 1.15 crores. On receipt of the said order dated 11/6/2025, the appellant has raised a detailed objection dated 12/6/2025, which has been received in the office of the respondent on the very same day, namely 12/6/2025, which could be seen from the date affixed in the copy of the objection. However, this objection is yet to be considered by the authority and no orders have been passed. Considering the fact that the case has had a checkered history and the appellant had earlier approached this court by filing a writ petition in WPA 9500 of 2024, and the refund has been unduly delayed and a partial refund has been granted during the pendency of the writ petition, we are of the view that the authority, namely the Deputy Commissioner of Revenue, should pass a speaking order on the objection/representation dated 12/6/2025. It would augur well to the asset authority to afford an opportunity of personal hearing to the authorized representative of the appellant, so as to enable them to place the records and other details that may be required to be considered. Accordingly, we dispose of this appeal by directing the Deputy Commissioner of Revenue, Commercial Taxes, West Bengal, Chandani Chowk and Princess Street Charge to pass a speaking order on the objection/representation made by the appellant dated 12/6/2025, after affording an opportunity of personal hearing to the authorized representative of the appellant within a period of 4 weeks from the receipt of the server copy of this judgment and order.
Need two humble submissions, my lord. Instead of refund, it will be interest.
Interest.
Instead of refund, it will be interest. And my lord, second, my lord, your lordship may kindly record, your lordship has not gone with regard
yes, that's what it is made clear that the learned senior advocate appearing for the respondent state submitted that the writ petition was not maintainable before this court, and therefore was rightly disposed of by directing the appellant to approach the West Bengal Taxation Tribunal. The rule of alternate remedy is a flexible rule, and the court and the Honorable Supreme Court has drawn several exceptions to such rule. So, which have to be which have to be applied by considering the facts and circumstances of the case, going by the conduct of the respondent department in not passing any orders on the refund application for a long period of time, and even after the writ petition was filed, and during the pendency, partial payment of interest was made. This court is of the view that the writ petition can be entertained by this court in the facts and circumstances of the case. That apart, an earlier writ petition filed by the appellant was also entertained by this court. Therefore, we make it clear that the merits of the matter have not been gone into, and it is for the Deputy Commissioner to consider the entire facts and pass a speaking and reasoned order on merits and in accordance with the.
Much obliged. Great for your lordships.
Item number 6.
It is the said matter, my lord, where the Central Tax Authority prepared the adverse report on the point of the.
Yes. Where is Mr. Udeshakar Bhattacharya?
I communicate by a letter. Today he informed me. Today still he is not being engaged. Even his junior is also communicate to him also, and he is also suffering from the fever. There is no certainty that whether he will be engaged in future or not.
He is suffering from fever, my lord. If your lordship kindly keep the matter next week, so that in the meantime also he can get the instruction from the department, my lord. If your lordship.
That the learned advocates appearing for the respondents 2 and 5 is indisposed and not able to attend court today. Hence, list the matter next week.
Next Tuesday, my lord.
Sir, sir, what about item 7? Is it very urgent? I've got some administrative work. Everybody is waiting here. Urgent administrative work.
Yes, my lord. I am for the respondent, my lord. On the last occasion, I failed to appear because of the change of number, my lord. I traced under the MAT number, but it has been renumbered as FMA. So, my lord, I missed the list.
Then we'll do one thing, sir. We'll take it up tomorrow.
As your lordship.
We'll stop with this today. The remaining matters we'll take it up tomorrow. Okay.
As your lordship.
Okay. Thank you.
Tomorrow, sir.